Welcome back, everybody. Good afternoon, good morning, good evening, depending on where you are joining us from. Many of you have already been here for the first webinar today and the previous webinar, so you know this already, but my name is Jean-Pierre Gauci. I'm the Arthur Watts Senior Research Fellow at BICL, as well as the Director of Teaching and Training. And it's my pleasure to welcome you to this last webinar in our series on teaching international law, where we're going to be focusing on decolonizing the teaching of international law. The webinar, as you know, is scheduled to last an hour 45 minutes. We have an excellent lineup of speakers. We're very much looking forward to the discussion. But part of that discussion is the questions that come from you as our audience. So please, we do encourage you to post those questions in the Q&A box, which you can see on the bottom of your screens. Keep an eye on the Q&A box, because if there are questions that you would really like to see answered, it would be great if you could upvote those questions, so that Maria, as the chair today, will be able to know that those are questions that people really want asked. We'll try to get to all of the questions, but we can't guarantee that that will be possible given time restrictions, but we'll try our very best to do that. The chat function on your screen is disabled. However, you will be able to receive messages on there. So if any of our speakers would like to share a link, for example, to a particular article or something else, that can be done via the chat box. I do remind you that the event is being recorded and will be uploaded onto the BICL website, and that more importantly, the recordings of all our previous webinars have already been uploaded onto the BICL site, and we can drop the link in the chat box for that. Having said that, it is my pleasure to pass the words to Barry.
Thank you, Jean-Pierre. For those of you who weren't here this morning, my name is Barry Sander. I'm an assistant professor at Leiden University. A confession, I'm actually quite sad because this is the last webinar in this series and it's been a really amazing journey. Thank you to everyone who's been involved with it, BICL, all the staff at BICL, my co-convener, Jean-Pierre, all the panelists, all the chairs, all the organizing committee, everyone in attendance. It's been wonderful. So I am upset, but I am also excited because this final webinar I think will be fantastic. We have a fantastic set of speakers and we have a fantastic chair who it's my pleasure to introduce, Dr. Maria Veracki. There's a lecturer in international law at the War Studies Department at King's College London. Previously, Dr. Veracki was Senior Research Fellow with the Eric Kastrian Institute in Helsinki, working on an Aristotelian theory of ethics for global governance. And since November 2017, she is also a member of the ILA Committee on Human Rights in Times of Emergency. So it's my pleasure to hand the floor now to Dr. Veracki. Take it away.
Thank you very much, Barry. Thank you very much, Jean-Pierre, for the invitation to chair this final webinar of your series on teaching international law. It's a great pleasure for me, and I'm very happy to be with you. Excuse me, I'm just recovering from, I'm slowly recovering from COVID, so you have to deal with my coughing from time to time. So having said that, you know, I'm very excited about this last session because exactly it's the topic that it's really so intriguing, decolonizing the teaching of international law. And having said that, you know, today we have 4 wonderful female speakers. I would like to highlight that. I'm very happy about that as well. In particular, on top of everything, who are going to share with us their reflections from the abstracts and from your contribution that I have read until now, their reflection from your personal journeys, you know, as teachers, but also as students of international law in different countries, different continents, but also not only from a different geographical perspective, but also from a different methodological perspective, focusing on particular case studies. Having said that, already Jean-Pierre has explained the procedure, so I don't want to take more time from our speakers. I'm going to continue to follow the line of speakers we have on the poster. So immediately I'm going to give the floor to Doka to share with us her reflections and her experience. Each of the all speakers have about 15 minutes. So the idea is all of them, you know, to complete their contributions and then to have plenty of time, you know, for Q&A and for further other interaction. So having said that, Udoka, you have the floor. Thank you very much.
Thank you, everyone. Good afternoon. I would like to thank the organizers, the British Institute of International and Comparative Law, for the invitation to be part of this diverse panel of scholars and for the platform to not only share my experiences of teaching international law, but also to partake in the knowledge and experiences of my fellow panelists. I want to thank Jean-Pierre and Barry for their support throughout this whole process. And I want to thank Maria Varaki, the chair of this panel. And my topic is on, if I may share my screen, please. So my topic is on is a personal reflection on the teaching of international law in Nigeria. Now, before I do that, I have to make a caveat at this point and say that this reflection is based on my own peculiar experiences and situationality. I do not approximate my experience to be the same for all teachers of international law in Nigeria or across the continent. Nevertheless, there may be similarities in our experiences, bearing in mind a shared colonial history. And so by way of a general background, the international law teaching in Nigeria, the Nigerian Universities Commission is the regulatory body for academic standards for all academic programs in Nigerian universities. And it acknowledges in its benchmark minimum academic standards for university programs in Nigerian universities that there exists a colonial legal heritage which still persists. And surprisingly, it does nothing about this. Now, the BMAS in 2007, the BMAS 2007 stipulates the objectives of legal education in Nigerian universities to include stimulating students to critical analysis and examination of the prevailing social, economic, and political systems of his community. And the more specific objective that the law curriculum in Nigerian universities must also ensure that law is taught as it exists at any given moment. Now, a juxtaposition of these objectives seems rather odd against the background that it recognizes that a colonial heritage still persists and it wants to advance critical thinking and analysis. Now, there's a 2014 draft which reviewed the 2007 BMAS, but again, it doesn't change this uncriticalness because it states, the 2014 draft states the main objectives and aims of the LLB program to be to ensure that law is taught as it exists and at any given time, again, replicating the 2007 BMAS, to ensure that students are imbued with a general knowledge and understanding of law, to develop in students the intellectual ability to apply research, knowledge, and analytical skills to solving theoretical and practical problems. And so that contributes to an uncritical space. Now, law is taught in the 5th and final year of undergraduate law studies as an elective, and it lists general themes that are to be studied. So it gives a list from the sources of international law to the law of treaties. It is important to note at this point that the BMAS prescribes minimum academic standards, and so that it is up to schools to be able to build on it. But it is unfortunate that despite its specificity, that it is minimal academic standards, it has been considered or treated as maximal academic standards. Now, my general observation, which is an observation that informs this reflection and shapes the discourse, is that the space international law is taught, and in fact that the space that teaching is done in Nigeria is an uncritical one. It's defined by the banking method, with students memorizing and regurgitating all that they have taken in. And this speaks to the teaching pedagogy and informs an apathy to international law in students in Nigeria. Now, an inquiry into this uncritical space and the logic that fails to animate the academic space involves journeying into the history of legal education and education itself in Nigeria, in which colonization is implicated. Now, colonial education had as its priority, the priority of colonial education emphasized, science, technical and vocational education more than the arts, and even less legal education. Now, legal education was formally introduced in Nigeria in the 1960s. So legal education was seen to be bad for imperial business, and education was left mostly to the missionaries. And the agenda of the missionaries was to educate the colonized for heaven and not to educate them for the society that they had to live in. And so the colonial education policy has been criticized as being unfit for purpose, literal and uncritical, a miseducation of Nigerians. And this is contained in some of the reports, the Fell-Stokes Commission report of 1929 and the Eric Ashby Commission report of 1959. Now, post-colonial education. The post-colonial society reflected colonial policies and again emphasized these colonial priorities, what Albert Memmi describes as the mummification of colonial society, where you had a newly independent country, and the elites of the newly independent country were trying to fit into the minds and the shoes of the colonizers. And the Nigerian National Curriculum Conference of 1969, which was instrumental in shaping the new Nigerian policy and philosophy on education, was pretty much built on the Eric Ashby report. And again, in this post-colonial education, there's also the impact of military rule. Military rule in 1966, Nigeria was launched into a military dictatorship by a coup. And one of the characteristics of the military dictatorship in Nigeria that ruled up until 1999 was that it was intolerant of dissent and radicality, and actually intervened in universities, from the appointment of vice chancellors and to the governing council of the school. And so again, you had this a culture of being uncritical, and even the democratic under the democratic dispensation that we've had since 1999, the echoes of the past still ring loud. And so the decolonization becomes an imperative for education in Nigeria and the teaching of international law. Now, the language, the term decolonization seems to be a very popular one. In fact, if you put into Google, decolonization of academia, you find almost 7 million hits, 6.8 million hits. And if you put into the Google search engine, decolonization of international education, you have over 3.9 million hits. So it seems to be a fad. Perhaps it's been, the apprehensions of it being a fad and or a gimmick for academic rebranding, but nonetheless, it's the whole point of this exercise is to critique it and to see that it is actually not a fad, that international law has epistemic dualist assumptions, that it is made in Europe and the West for its interest, and it is made for the regulation of non-Europe and the West, as well as the implication in colonization, impel this discourse on the colonization of international law. And this is especially when international law is considered as a formulation of a body of principles that are understood to apply globally as a result. So they applied globally as a result of the annexation of unoccupied territories in Australia, the conquest of many parts of Asia and the partitioning of Africa. And so as Anthony Angie argues that a colonial confrontation is central to an understanding of the character and the nature of international law. An international law that has been dominated by Eurocentrism. In fact, Koskiniemi criticizes, in criticizing international law, describes this Eurocentric dominance as the most remarkable feats of international law self-construction. And so there is an imperative for decolonizing international law in Nigeria. And so how do we do that? And some of the critical approaches to international law have to be considered, of which you have TWAIL, the third world approach to international law, critical race, feminist Marxist theories, for understanding international law. Now, these theories interrogate power, and particularly TWAIL interrogates and resists Eurocentrism's universality and the hegemony that is prevalent in international law. The available texts and materials that are used in teaching international law in Nigeria are steeped in these Eurocentric ideas of international law and propound its principles. So even the textbooks that are written by Nigerian scholars do not really change the dominant narrative or depart from this paradigm. And on Bupinda Chimney, one of the 12 scholars in a project, the Teaching and Research of International Law in Asia project, said that teachers of international law would be failing in their duties if they did not acquaint their students with the mainstream view, but at the same time would not be doing any justice to their students if they did not tell them about how different critical approaches, feminist, Marxist, TWAIL, and others, explain the logic and dynamics of an international system that results in half of the world still remaining poor, marginal, and oppressed. And this is why international law, the agitations for its decolonization remain. And so twailing, and I ask, are we twailing for TWAIL's sake? The theoretical commitments of TWAIL means that its introduction into the teaching of international law in Nigeria would require more than just mere tokenism. So these theoretical commitments of inequality, agency, inclusion, anti-superiorization and inferiorization, and subaltern knowledge locations would have implications for pedagogy, so that traditional modes and models of teaching, which are these lecturing and banking methods that already serve to normalize, hierarchy to some extent through the non-engagement of students in the learning process. The introduction of TWAIL would have implications for pedagogy and classroom dynamics. So by introducing some of or rather de-hierarchizing the structures of the classroom dynamics, and also introducing a dialogic teaching and learning, which would spur innovative pedagogy. And so the pedagogy then becomes answerable for the power relations that they produce, according to Alford. Now, innovative teaching, which is, my argument had been that if we introduce critical scholarship and like TWAIL, that it has implications for teaching pedagogy, and which would become innovative. And what are some of these innovative teaching methods, of innovating teaching styles in international law in Nigeria? Lectures still play a big role in teaching international law. But again, I will speak to my own situation. I teach in a private university, and so that has invested in ICT and technology. And so the role of ICT and audiovisuals help a lot in lectures, and as such, change sort of affect the dynamics in the class and encourage this dialogic teaching. So for example, I use smart boards. I use smart boards to teach. And by using smart boards to teach, it means that I can go into websites, I can pull up treaties themselves. I can pull up treaties and then the students get to see the treaties. And so it sort of engages the students at the same time. I like to teach always by having a map of the world as I teach international law. And so having a smart board readily makes it easy for me to access a map of the world. Again, the place of audiovisual. So sometimes certain topics I might show a short clip or I might be able to show a video. And so these help the teaching, these help the lecture. This helped me in the lectures. Again, I adopt case studies and analysis, again, with a view towards this dialogic teaching. Debates as well, where I encourage my students to argue counterintuitively as well, because I think that this is necessary for developing an analytical and critical thinking. I also deploy simulations. And so I have found role play actually to be very popular for the students, for my international law students, particularly in teaching the law of treaties, for example. So I deploy role playing, doing things like treaty drafting and dramatizations, and the students really like that and are very engaged and actually go over and beyond, the readings you expect them, because they want to give a good account of themselves and actually become competitive in that regard. Now, Moots, the Nigerian universities, legal aid institutions in Nigeria, NULAI, have tried to introduce law clinics across many universities in Nigeria. And so in my university, there is a law clinic. And to the extent that I am able to use them to teach some of the topics that I would teach, again, bearing in mind that the teaching of international law, and the topic that you're teaching would determine how much of itself can be lent to to clinical education. But nonetheless, this is something that is available. Again, something that I use and I encourage others to is the use of social media. And so because the students are actively involved in social media for their own entertainment, I want to co-opt some of that for education. And so I encourage them to, for example, to follow the African Union on Twitter, or to follow to follow them on Instagram. And so I encourage them, people to follow, and sometimes we discuss some of these things as they arise. Now, I want to also say that innovation, the extent to which these innovative methods are used is dependent on class size and the resources, as well as the amenability of the topic, to the style and infrastructural challenges. So again, with power supply and temperamental internet services, again, limit the extent to which some of this is done.
I don't want to interrupt you, just to remind you that you have actually 1 or 2 more minutes, if that's okay, to complete your thoughts.
Okay. I'm almost done.
Yeah.
I'm almost done. And so I want to, against this backdrop, I want to foreground certain challenges. And some of the challenges have been, a pandemic, obviously, and online teaching, and the imperative of, ICT. Again, private universities, as I mentioned earlier, I teach in a private university. With the pandemic and online teaching and the deployment of ICT by private universities better than the public universities in Nigeria, it has made private universities more attractive. And so there are more students who are coming into private universities. But again, on the other side is that the number of private universities are on the rise. So you have 96 public universities, of which 44 are federal and 52 are states. But on the other hand, you have 99 private universities. almost 60 of which in 10 years were established in 10 years, and with 20 alone established in 2021, this year alone. And so there is that is something that has to be considered. And this is especially against the backdrop of that teaching and research support and funding. So for example, under the TET fund, which establishes a national research fund as a special intervention for encouraging teaching, is applicable only to public universities and not to private universities. And as I mentioned, private universities have now eclipsed public universities in number. Again, there's the challenge of the access to academic resources, online subscriptions to Hein Online, and the rest of them with the inflation and exchange rates make it difficult. Now, my concluding thoughts, my concluding reflections, something that can be done. And the teaching of international law in Nigeria needs to become critical to counter problematic narratives and the exclusion of Africa as an epistemic site of international law. And for this, I want to propose something that can be done. While there are institutional reforms and bigger reforms that can take place, I want to propose to us as teachers of international law, especially teachers of international law in Nigeria, to reimagine ourselves on the other side of the lectern, to rethink our international law course, and to redesign our lesson plans. And if you don't know where to start, avail yourself of the extensive 12 bibliography already compiled by James Gatti in his gracious lecture on the promise of international law. Thank you very much to everyone.
Excellent. Thank you very much, Udoka. I really love your the whole presentation, but especially, you're urging us, how to rethink ourselves, from the other side, if I can say that, and also not only for limiting yourself, to describing the situation in Nigeria, but also sharing with us your personal input and how you deal with that. So that was extremely insightful. So having said that, now we'll give the floor to Carolina. Carolina is going, I feel that this session is a kind of zigzag. So we started with Udoka sharing with us experience from Nigeria. Now Carolina will talk about more of a case study or of a phenomenon, and then we'll move to Giovanna again, sharing experience from other countries. Having said that, Carolina, you have the floor. Thank you.
Thank you so much. Thank you for the invitation and the opportunity to present here in this great series of webinars. I would also like to mention, a bit echoing Udoka's disclaimer, that this presentation contains my views. They might be different from the views of the organizations that I discuss, especially the case studies. I am not affiliated with these organizations, and yes, my views might be, of course, different than other students or researchers in the regions that I discuss. So what I would like to focus on today is the teaching of international law, specifically international humanitarian law, IHL, through ancient rules of warfare. So generating respect for IHL is apparently one of the hardest challenges faced by humanitarian actors on the ground nowadays. The evolution of different types of conflicts in which the opposing parties are no longer states, but rather a complex mix of non-state actors, calls for an informed response to this crisis. And this response that takes into account local needs and realities, both of the civilian population and the armed groups themselves. So an Icrc study, this is the first case study that I'm going to discuss, from 2018, titled Roots of Restraint, identified different factors that have an impact on the behavior of armed groups and on IHL compliance. So this included the study of integrated state armed forces. Then they looked at centralized and non-state armed groups, decentralized armed groups, and finally community embedded armed groups. And they have found that there is a need for an approach that focuses on both law and the values underpinning it. So importantly, emphasizing the identity-based nature of restraint could help to encourage compliance in cases where soldiers or armed groups question why they have to respect IHL when their enemies do not. Also, there is evidence that civilian communities can positively influence armed actors and limit the violence, particularly if the community is cohesive and well organized. So strong communities can implement local conflict resolution processes. And quite importantly, African Union has declared the year 2021 as the AU Year of the Arts, Culture and Heritage. So perhaps it is the perfect time to launch and expand some of these initiatives on teaching IHL to the armed groups, but also broadening and encouraging the local population, academia, as I'm going to discuss later, students to contribute to this research, which will enable these initiatives to grow and develop further. So now I will discuss these two initiatives by Geneva Call and ICRC that I think are worth replicating in different regions on different continents. And I do not think that they're only applicable to Africa, but I think these methods could really be successful in other places too. So the widespread violence against the civilians in Mali and the difficulty in appealing to armed groups that largely reject the Western humanitarian law resulted in the need for a new approach. So namely the common ground approach, as opposed to imposing just Western international law on the armed groups. So an illustration of this application of this approach to IHL can be an exercise that was carried out by Geneva Call between 2018 and 19 in the communities in Mali. So this exercise, it consisted of local level community consultations in 2018 and the roundtable discussions in 2019, and this allowed for an identification of the society values which correspond to the relevant provisions in IHL, so the Geneva Conventions, relating specifically to the protection of civilians. So the hypothesis of the exercise was that relying on local traditions and principles, including religious values, might have a wider resonance with the local armed groups and could enhance the IHL compliance. And they found that local values that corresponded to modern IHL and strengthened the message of the need for civilian protection. So in their study, Geneva Call relied on ancient community rules as receptors, sort of. And the roundtable discussion under Chatham House rules had the objective of identifying the points of convergence or divergence between several sources of law like IHL, but also Islamic law, customary law, social standards, concerning the protection of civilians. And the roundtable discussion and presentations covered the topics of traditions and proverbs, history of empires and kingdoms, and the teachings of behavior in armed conflicts. So about the different groups that were invited to all of these studies. So these were representatives of youth organizations, women's rights groups, religious leaders, and local authorities were invited to share their views. And Geneva Call was able to identify the relevant traditional rules and principles for the purpose of identifying the common ground with these IHL rules. So the pragmatic aim of the mapping exercise was to draw the attention of the armed groups to the rules governing the conduct in warfare of their ancestors that they sometimes try to identify with from pre-colonial times in order to enhance the compliance with IHL. And here I think the real challenge, but also the added value of this kind of mapping exercise comes with the distinctiveness of the rules in each traditional society. Let's face it, they're not all the same. And with the need to identify the authentic values and cultural practices in each of the society, as opposed to just transplanting the contents of the previous training to the new training with armed groups, for example. So this is essentially the outline of the study of Geneva Call, which obviously is quite concentrated and community specific. The study of ICRC that I want to focus on is more general, so which means it is looking at ancient rules of warfare from many different communities, but it also has potentially more far-reaching impact also because of the nature of ICRC as a very big organization. So in the late 1990s, the legal advisor in the Pacific initiated an ICRC study called Under the Protection of the Palm. So the idea was born to draw correlations between the principles that existed in these traditions already that correlated similarly to the Geneva study, Geneva Call study, that correlated to the existing principles of IHL. And there were, for example, correlations between the protection of the emblem in times of armed conflict, and then the protection of something they had similar, which was like a palm leaf that they used. So the study showed the correlations between the traditions and principles of IHL, and in this way, the ICRC was able to engage with local authorities on the ground, with tribal councils, tribal elders that existed in the Pacific. So it was really an opportunity for ICRC to have the grassroots approach to IHL as opposed to teaching something that is completely detached from the reality. And then the ICRC legal advisors really took this study and used it in the engagement with the local authorities all over the world. And then in 2018, they decided to use something similar to this study in the Pacific, to use it in Africa. So they're also confronted with the idea that IHL was a Western construct as everywhere. They wanted to come up with a tool that they could use across different types of audiences, that they could engage with, including armed non-state actors across Africa. They started drawing examples benefiting from the fact that ICRC has both resident and mobile staff all around Africa. And the idea was to come up with a tool that is essentially, at the moment, what looks like 11 cards. They look like flashcards. On the front of the flashcard, there is an image of the traditional custom, and on the flip side of the card, we have exactly the tradition that it comes from, which tribes in Africa implemented this tradition, and then what principle of IHL it corresponds to. Their objective, for example, is to be used in the field in the operational context, where there's conflict. There are also different delegations in Africa that came up with the idea of cartoon pictures on the playing cards. The idea behind this is it would be a gift to non-state armed groups at checkpoints, in a way, just to show them what IHL is. So it is something that was born out of long-term informal work of ICRC. It is not a result of a multi-stage consultation, but may well result in something. So I just suggest that something that Geneva Call did could start with what ICRC did, and vice versa. So on a different note, in South Sudan, ICRC used wrestling competitions as a metaphor to explain the rules of IHL during a first aid training session with local groups. So ultimately, the potential of success of such approaches of teaching IHL to armed groups differs, of course, depending on the level of concentration of the armed group, something that was explored in the Icrc study on the rules of restraint. The higher the centralization of the group, the higher, in theory, should be the respect for the authority and rules, but at the same time, community-embedded armed groups can, in theory, be more influenced by the local society customs and traditions if they are shared. And I think what is important is the potential of these initiatives to spark interest in IHL in whatever form, also of different group members, not only armed, caring people, but also children and adolescents and elders, in a way appropriate, of course, without some graphic images. The IHL research is really happening at the moment, I think, in a vacuum. Outside of Africa, of course, I mean, in the Western institutions. It focuses on studying sometimes the history of negotiations of treaties, but it really does not engage with local community in the form of, and I suggest, inviting African professors to cooperate on international projects, inviting African professors to author books or special issues of journals that these professors then could engage their students or research assistants or other people from the community to contribute to these projects. In this way, it could be better connected to the community. And on purpose, I have not used this word, decolonization, because I believe we're not yet even at the start of any kind of decolonization in IHL especially. And now, in order to broaden the perspective a bit, if I can say something about IHL compliance in my region, which is Eastern Europe, where such initiatives, I think, are very needed at the moment, unfortunately. So when we think about regions which are involved in armed conflict at the moment, there are also regions directly bordering, for example, the European Union. We have an armed conflict in Ukraine with large-scale atrocities and concentration camps where torture and sexual violence is committed on a large scale. The same type of initiative that I mentioned could be started there, of course, not in the region of Donbass, but in general in Ukraine, across the lots of different institutions. And instead of funding a large-scale IHL dissemination and teaching projects and inviting local civil society and engaging with local communities, someone can say that European states are focusing on building more gas pipes and oil pipes. So with some of the arguably imperial aspiring states. So that sounds familiar, I think, to other regions that we're faced with this. So something that starts, and I argue, with an academic exchange and cooperation could have impact on the growing interest in IHL of local communities, but it needs to be done step by step, like ICRC and like Geneva Call did. So with professors, for example, I suggest then going top down. And at the same time, initiatives such as ICRC and Geneva Call, which are very grassroots level, could help teach and disseminate these principles on the ground. So, but for that, they need wide-scale research in order to then create these cards and to create other initiatives. So I believe in this way, a real decolonization could take place because, as already observed by a number of 12 scholars, it is not only African armed groups, but also Eastern European communities that did not have an influence on the negotiations of the Geneva Conventions, for example. And this is where large-scale atrocities are happening today. So one of the ways to address this is to start pragmatically focusing on the problem of IHL compliance locally. Thank you.
Thank you. Sorry. Thank you very much, Carolina. One more very, very personal and very interesting, intriguing presentation. As I said, you know, this is a kind of zigzag. I'm teaching international humanitarian law, so I was very happy, you know, I know about also the cooperation about Islamic law and the development, you know, to what extent of Islamic law, but we will discuss a lot more during the Q&A. Having said that, I would like to give the floor to our next speaker, Giovanna, who is going to share with us her experience also both from Brazil and UK. I have to say here that Giovanna is currently based at the University of Lincoln. So I would like to make a clarification on the poster. And Giovanna, you have the floor. Thank you very much.
Thank you, everyone. Good afternoon. I would like also to try to share my screen and see if it gonna work out well, hopefully. Maybe this one. Let me see. Cool. I think everyone is able to see the slides. So again, I think it was really interesting for me to hear Udoka's presentation because we have like so many similarities that it kind of seems like unbelievable to a certain extent. So again, I'm gonna be focusing now on Brazil. My presentation touches on some elements that Udoka has already mentioned, but maybe I'm a little bit, how can I say, less certain of the steps where we have to move about to kind of try to change the context that we are living in, or what is the scope of our responsibility as lecturers, you know, how much we can actually ask from us as a lecturer of international law on this process. And I also check the question that it's already put on the chat, and I think it will be interesting to see what we see as a potential for decolonization. But what I wanted at first to bring to attention is I studied international law in Brazil as an undergrad and as a postgraduate student. And I taught international law in Brazil for almost 5 years, most of it at a university, a public university in Rio, Universidade Federal Fluminense. And this is kind of maybe a difference that I can already identify in relation to Udoka in Brazil. We have, how can I say, maybe the perception that the public universities are a little bit stronger still than the private universities, if we compare all of them. No, but of course there are some amazing private universities, and again, some that might not be that strong on the public universities. So it's difficult, also if we're talking about consider geography of Brazil to present something like this. How can I say, this is the reality, no? We have so many differences and the context of inequalities to a certain extent, so significant that it's hard to make a conclusive point of where to go or how to go. But this is actually to a certain extent also what has guided my interest, or a little bit how to go on the details of how I would approach the topic. So I'm trying to see if what I could talk from Brazil in general, and this will bring for me a little bit of the perspective and the discussions that I'm looking at here. So this slide is kind of an attempt to bring forward or put forward what would be my presentation, the steps of the presentation, but also to give some of the context. And again, here we see the reference to, I didn't go to the colonial period, but could have gone that far away, as for instance, in Brazil, all of us, if you're a lawyer, you're a doctor, as if you are, how can I say, you studied medicine, and if you have a PhD, so we're all kind of the same level. And you actually have a legal legislation saying that you should call all lawyers as doctors in Brazil. So you can see from the colonial period how the social strata and the perception of the position of people in society takes place. No? But I came back to 1988, which is for us an important mark in our history, because that's when we have our new constitution leading aside like representation, the democratization process. No, so we're just finishing up with the dictatorial period. And our constitution, as you probably guys are aware, we have like an amazing list of human rights prescribed in it, like one of the famous one. And among them, we have the education. And it's interesting to see that actually when we're talking about education in Brazil, it is considered a right, and it's considered like also imposing duties for the government, including to a higher education. So we have a statement, like one of the provisions saying like the government has a responsibility to provide access to higher education to the extent of the individual capabilities. So this is our idea or underlining idea. And we even have on the constitution what this education should aim. No? So it has the idea that, well, we are preparing citizens, that's the background, and also qualifying our workforce. So those will be some of the principles that we have when you're talking about higher education. And it's when we leave, how can I say, or when we have this overall understanding of the relevance of education and what it should be achieved when we're talking about it in the democratization process, we can see a huge expansion again of, how can I say, the higher education institutions. Probably it's not representative, the proportional over there, like in terms of the graphics, but that's what I'm focused about. So I'm talking about higher education, I'm talking about the study of law, and then there is a little bit of representation there because nowadays we have almost 10% of our undergraduate students in Brazil study law. No, we can put that on the overall variety of time that we have and courses, we can see how many. And then my focus actually is that like little red dot over there. Maybe it's a little bit too big still because we have in Brazil like a 5 years degree, between 5 and 6 years. We have on the regulations for our curriculum, we asked to teach about 3,700 hours of law. And among those, like more or less maybe 100 hours are dedicated to international law as a mandatory module. So we can see here the, how can I say, how we situate the relevance of international law within our overall curriculum. Of course, all the institutions can go on and have electives in relation to international public law, but this is the overall idea and time frame. So I'm basically like, even though here everybody's really interested about international law, I just wanted to make sure that we have in context what is the overall perception of the relevance of the subject when we're dealing with it. You know? So I'm going to be talking about that tiny little dot in this slide. So when we move then a little bit with the topic, and here's just a representation, hope you guys can see more or less the graphic over there of what has happened in terms of higher education in Brazil concerning the law courses. So in 1996, we actually have a law that provides us the guidelines and framework for legal education, for education in general, and then we have a concern with higher education, and actually has made like the rules more flexible, allowing us for, to a certain extent, the overall idea was let's promote access to higher education. Nowadays, we look at it from another perspective as a context of proliferation of higher education. So what was seen initially as positive nowadays is a little bit more negative. So what we have here is like until 2017, and I'm sorry for the difference or discrepancies on dates for the comparison, but I think you guys will see. We'll have the idea that until 2017, we have 1,203 courses of law in Brazil, and the escalation of it. Like 2013, we actually break it a little bit because we have like a regulation that no courses should be open for a certain amount of time. 2020, it's like this year, we basically have now 1,775 law courses. And this comes to a point where actually our Bar Association comes and asks our Supreme Court to interrupt the creation of new courses for at least 5 years. And this is kind of interesting too, and I forgot to mention that on the previous slide. So on the background over there, we actually have the office of our Bar Association. They, like lawyers in Brazil, have like the role on the constitution saying like, okay, you are relevant for the administration of justice. And there we have the relevance of the context. They also have a role in relation to the creation of new courses established since 2017, saying that the Ministry of Education has to authorize a new course after having heard the Bar Association. So we can see also the power of our institution in relation to that. And that concern comes across, or the involvement with higher education comes across, because 80% of those who actually graduate in law and try the bar exam have failed it. So we can see that maybe promoting access to higher education doesn't really mean promoting that we are qualifying our students for work, no? And even when we talk about that, what does that mean? No, like how we're thinking about promoting or creating lawyers, and they're gonna work in which type of context and so on. So to deal with this type of situation, we actually, how can I say, have been attempting, since we kind of identified the problem. And I would say maybe we have two main routes. One is trying to go on and regulating the law courses. And this has been done for quite a significant period of time. And nowadays, our most current regulations is from 2018. And we're going to have there what are the objectives that we have on these regulations is that we're striving for humanistic formation. We want them to develop analytical skills, have adequate argumentation skills, reflective posture, and critical vision in relation to all the modules. We have international law as a mandatory module, and this has happened since 1996. So during the dictator period, we actually have it as an elective. Okay, so 1996, when we change the legislation, comes the constitution, then we move our way from focus on the national perspective and broadens up the perspective to the international context again. So here would be like some of our regulations. And even though this regulation is quite recent, we can say 2018, it actually goes back. No, so it's not something that, how can I say, it reproduces previous resolutions. So 2004, we have a similar structure, and this has already been pointed out there. So international law then is considered for us like one of the disciplines, modules that we have to have. It's part of the technical and professional training of the lawyers, has to be present and offered by any institution dealing with international law. And it's kind of interesting too, because the resolution itself says we have to think international law in context, and we have international law in any of the other subjects. We have to think it in context. We have to take care of the political, cultural, and social changes that have taken place, including those taking place on the international context. So we could say that there is a lot of space there for us to kind of develop a critical perspective, like to consider the role of international law on keeping inequalities or constructing inequalities and so on. So this is the reality from what we see on our regulations. If we then look at another attempt to regulate those courses, we have the exams. So we have one exam that is actually done by the Ministry of Education, one of the specific institutes that we have, and they actually take into account student performance when they are dealing with the courses. And this is kind of an assessment that the students on the last year of the law course take it. It takes place every 3 years. So they do that, and we can kind of have an overview of how the students are doing. Take it into account the infrastructure, the facilities available on that particular university, and also like the profile of the lectures over there. But my focus here would actually be on the second type of exams that have evaluations, and those are the ones conducted by the Bar Association. So here, like as I mentioned, for us to be a lawyer in Brazil, you do have to have a legal degree and pass the bar exam. So those, you cannot like have studied medicine and do the bar exam. You have to have the legal degree. And with that, later on, you can actually, from your 5th year, already go and do the bar exam. So the first phase of this bar exam is actually a multiple choice exam with 80 questions. There we have two questions of international law. And the interesting bit is like international law here, it's not necessarily international public law, but it might also fit international private law. So basically you can end up with a bar exam evaluating like a student that doesn't touch on international public law at all. No questions are asked on that line. We can say this is amazing for us, international law lectures, because then we don't have the pressure of trying to kind of make sure that the students pass those questions, but it also shows like an overall understanding of what is the relevance of our subject. Now, how is it perceived institutionally, and how is it perceived by the institution that actually has a significant role in administrating justice in Brazil. So there we go on some of the contradictions that we can find it out. The second phase is actually the production of a legal document, and then international law is definitely not there. We have civil law, we have contract, we have corporate, we have constitutional law, criminal law, and so on. but like not something that we would have a look at international law. To be kind of fair with us here, whenever you're talking about international law, there is another set, like human rights nowadays have two questions too. And human rights for us can be treated from both sides, no? From constitutional law, as I said, we have a significant list of rights over there, but also from the international perspective, okay? So it also depends for the institutions. Some of the institutions are going to have a specific module on human rights, and then depending on what they put in each of the modules that they have, be it international law or be it constitutional law, you kind of can decide what is the approach that you're going to have in relation to treating human rights. So we have all this type of flexibilities to a certain extent. No, none of the contents are already described for the institution or even for the lectures themselves on how they're going to approach those questions. So what I wanted to bring now is like an example of a question, and I'm sorry, I'm going to just refer to one example, just taking into account a little bit of the time. So here, and I'm not sure if you guys can kind of read it, but just, how can I say? It's an example from a question from 2019 on our exams. And it's actually the only question that kind of would fit more or less with the perspective of international public law if I consider human rights within that framework. And we're going to see here that it's like, this is the type of question it's the scenario that was being presented. It's basically discussing, well, what are the obligations of the Brazil after ratifying the International Covenant of Civil and Political Rights? Can we suspend some of those rights or not? And how does it go about it? No? So those how can I say? I'm sorry if there's some mistakes on the translation here. It was an open translation that I did. I hope it makes sense still, but this is the idea behind the question. And those are the options that we expect our students to answer, okay? So, and again, like, how can I say, the options here is just to kind of illustrate and bring about what is it that we ask from a student. Now we say that we are looking for the skills to be like reflective, to be critical, to be analytical. And there we have the text. Now is it like, do we need just like how can I say, a formal act by the legislative and executive that limits that it's only for 2 years that we can suspend those rights? No, a state cannot suspend any of those rights at all. Or do we have anything like, how can I say, the difference between a strong sense or soft sense of human rights, taking into account the covenant and the constitution? So here again, we can also see the link between how we go about treating the relationship between international law and constitutional law. And again, the first one, which is marked as the correct answer, saying that, like, yeah, depending on the situation, we can suspend, but it cannot be discriminatory. So this type of information is the type of information that we are asking for our students, no? And how can I say, depending on the student that we are actually dealing with, this type of information make me even wonder, why do we need an international law lecture? No, like, to a certain extent, if they read the document, they will already figure it out. It's just like, we wouldn't really need to be there discussing with them and exploring those contents with them. So how do we position ourselves? What are we teaching? No, and for what purpose are we teaching? So, and I think this is kind of, how can I say, my last slide, and this is where I bring about, like, maybe not a certain certainty of where do we go, but some of, how can I say, the challenges that I identified, no? So I was fortunate enough to be teaching at a public university where, like, my job after like probation was not at risk, no? So we have a certain, how can I say, flexibility on how to deal and where to go with our choices. But the one point that I wanted to highlight is, like, part of the reality that we face is that depending on the institution that we're actually teaching, and taking into account the number of courses that are now available, your job might actually be at risk if you don't train your students to pass the bar exam. So how do we position ourselves in relation to that? You know, we do need the job to your human beings too. How do we position ourselves? How critical can we be to this type of context? And how do we reinforce or end up needing to reinforce a system like maybe of inequality and probably like reproduction of this overall Eurocentric system? Now, how do we go about it? So this is one of the questions that I put, and I put that like, okay, there I was relying, let's blame the institution, no? But I don't think it's even fair for us to think on those terms. Like, if we think even about our students, and if we are to consider them seriously, now as someone that we usually say, well, let's adopt methodologies where they construct the knowledge with us. So what does that mean to construct this knowledge? No, like a student sometimes enters like the law school because they have been advertised the chance that they might end up having like an amazing wage, or even if they don't have an amazing wage working like on a public institution, but if they end up working as a lawyer, or sometimes like just by having a, how can I say, undergraduate degree, they already have an increase of 30% of their wage. Okay, so how do we go about that? What are we really expecting from these students? So are we really willing to kind of ask, why are you attending a module? It's not an elective, so why are you interested in this module? How do we go about it? Or what is our position over there? How do we construct this knowledge together? And again, I bring back the idea of overall inequality in Brazil. No? So my students at the university were like at a public university were for a certain level. Those that are actually working throughout the whole day, paying like something around like maybe 70 pounds nowadays per month, considering the difference on our rates, exchange rates, are different. Those that are actually paying like 700 pounds per month to attend a private university, that is basically the university that nowadays makes the bar exam, and it's considered like one of the best ones on private terms in Brazil, they are different too. So how do we go about it? You know? How do we change, and where are we supposed to be challenging the process of colonization and this inequality and the overall ability that we have in the system to kind of exploit different views and so on. So I think like my concern is just like, as a lecturer in Brazil, we do have some of the guidance. We have the guidance of MEC, we have the institution presenting us, the Bar Association presenting us with some requests. We have our own concerns and our own beliefs of and expectations, what we expect from our students. And how do we go about all those? And even talking about our students and considering those. And this is like the amount of flexibility we have. It's just I copied here like an example from the University of Brasilia where I studied. When you come as a student to choose like which university you're gonna go, you're gonna have an indication of the content of international public law as listed below. Sources of international law, subjects, law of the sea, international responsibility, dispute settlement. Does that say anything to any of us? No, like when you go into detail, does that tell you where the course is going about? And if I, as a lecturer, when I get that, how can I play with these instruments and work on those? No, so I think these are, how can I say, maybe more of my questions and the questions that I put forward when I was teaching. And then like those questions also, I understand, probably different from the questions that I presented and put forward when I was teaching at the postgraduate level, but it's some of the issues that made me like maybe a little bit uncomfortable and continue to make me a little bit uncomfortable, not to what extent we reflect our context. And by adjusting our expectations to our context, we keep the colonization process or avoid the decolonization of our curriculum. So I'm not 100% sure if I went too far away from my presentations. I'm sorry for that if I spend more time than possible, but thank you very much.
Excellent. Thank you very much, Giovanna. I think there are many similarities with Udoka's presentation, as you highlighted at the beginning, you know, and I have to say that I found very, very thought-provoking the title, you know, of the presentation, Situated Knowledge. And I think this is a common thread we have, and we should try to use it as a bridge, you know, among the presentations. So I stop here because we run out of time, and I want to be fair to our last speaker, Priyasa. I'm sorry, I hope I pronounced correctly your name. Again, as I say, this is a final zigzag. It reminds me your presentation, maybe I'm wrong. I thought, you know, that it resembles to Carolina's presentation, focusing on a particular case study. So Priyasa, you have the floor. Thank you very much. And I would like also to remind or to encourage our attendees to use the Q&A function button. Please raise your questions over there. We monitor the questions, all of us, you know, and we will try to give the floor to all of you if possible. So thank you.
Right. Thanks, Maria, for the introduction. Thanks also to Barry and Jean-Pierre for organizing this excellent and very timely series of webinars. I'd also like to thank my fellow panelists for their really engaging presentations and also the audience for having zoomed into the session. The theme of this session is decolonizing the teaching of international law. There are many meanings of the term decolonizing, and there are several different ways in which we can go about decolonizing our teaching. I think that one of the most significant aspects of decolonizing education is contextualization. situating knowledge, as several of the other panelists have also talked about. And this involves making explicit to students that foundational ideas in all disciplines are not universal, but instead they emerge within specific social and political context and in a particular time. And by enabling students to understand that law is the product of political contexts and contests, we can also move towards identifying alternative ways of seeing the world, or hopefully anyway. Now, since context plays such a significant role in decolonization, today I'm going to be talking specifically about our current context, about the pandemic, to try and think through some ways in which we can teach international law through the prism of global events, which is the title of my talk. Now, like a lot of other people, I have spent the past year working from my home. You can probably see my kitchen in the background, actually. The UK is currently easing its third lockdown, and although things are improving here, it's much worse in other places. My home country, India, is currently reporting 300,000 cases a day, and healthcare systems have collapsed. Even in the UK, the last year has been a continuous stream of devastation. Thousands have died, thousands have lost work and livelihoods. Social and racial inequities have widened. The vaccination program has been quite successful here in the UK, but even that has seen significant disparities based on race and income levels. Lockdowns and other restrictions have also affected higher education. So students have faced isolation and financial stress, and staff have struggled with increased workloads in the face of the pivot to online and blended learning. One of the lasting effects of the pandemic has and might be the institutionalization of hybrid learning. So for instance, my institution, the University of Leeds, has signaled that physical lectures will in all likelihood be replaced by pre-recorded videos that students will watch as part of preparing for interactive small group learning. That's how we've taught this year, and that might be how we teach in the future as well. Today, however, I want to focus on how the pandemic has, or perhaps should, affect the substance of our teaching. And this is because law is everywhere when it comes to the pandemic. We can see this in the extensive restrictions that have been placed on our ways of living, working, and traveling, all of which were imposed through law. International law in particular has been deeply implicated in the pandemic in many ways. So for instance, a number of countries have instituted border control measures to stop the spread of COVID. And this raises complex questions about nationality and about protection. International law was also at the focus right at the start of the pandemic, when there was a controversy over the declaration of a public health emergency of international concern by the World Health Organization and whether it had been done too late. There's also currently a raging debate over international intellectual property rules and access to vaccinations and other kinds of critical medication. So how can these debates then influence our teaching of international law? I want to take a moment to acknowledge that there is a danger in focusing on crises in order to understand international law. So Hilary Charlesworth has persuasively argued that we should instead focus on the everyday, on the general structures of international law. But it's clear that the pandemic itself has exposed long-standing global inequalities. So I think that using the pandemic as a lens to examine global structures can build upon the extensive work of critical scholars of international law on the many ways in which international law creates, exacerbates, and perhaps even challenges hierarchies. Now, despite the considerable and varied critical scholarship on international law, teaching in the subject, and here I include my own teaching, often remains resolutely traditional, right? So modules, we often start with a discussion of whether international law is law, perhaps in combination with some kind of standard historical narrative of progress relating to international law's role in the global order. The topics covered are almost always the same. So we have subject, sources, jurisdiction, state responsibility, dispute settlement, the use of force. And more in-depth modules may additionally include discussions of specialized areas, such as international human rights, international humanitarian law, international environmental law, criminal law, or trade law. The global regulation of health rarely features in syllabuses on public international law. So sometimes we might consider the World Health Organization when discussing international institutions and the right to health when talking about economic, social, and cultural rights. But apart from these brief references, most international law modules have little space and time to engage with issues such as global health inequality. So how then can we properly reflect on the enormity of the events of the past year in our teaching of international law? Now, I think there are 4 possible ways to think about our pedagogy in light of the pandemic. So I'm going to talk briefly about each of them. The first response to the pandemic could simply be, let's include a topic on global health in our international law modules. This is a relatively straightforward change to make. It's something which I'm doing for one of the postgraduate modules on which I teach. So I'm part of a larger teaching team in that module. I only teach one topic. Last year, I used that topic to focus on human rights and development. This year, I'm going to examine global health governance by focusing on 4 main issues: histories, actors, legal frameworks, and political economy. So as a legal historian, I think that it's essential to teach students how to critically examine the historical roots of modern institutions in order to better understand current world structures. So when I'm going to teach this topic on global health governance, I'm going to start with a discussion of the long histories of global health, and in particular focusing on the significance of colonized territories in the development of global health institutions. Then I'm going to discuss significant actors in global health, looking not only at the obvious ones, such as the World Health Organization, but also trade and financial institutions, such as the World Bank, the IMF, the WTO, as well as private actors, such as the Rockefeller Foundation and the Gates Foundation, all of whom play a critical role in global health governance. Now, by examining the complexity of the global health landscape, it's possible to raise questions about what sort of actors are considered to be subjects of international law. Global health also provides an excellent lens through which to examine sources of international law and the processes of international lawmaking. So I'm going to focus on the Global Health Law Trilogy, right? The Framework Convention on Tobacco Control, the International Health Regulations, and the Pandemic Influenza Preparedness Framework. We can probably talk about that for quite a long time, actually. Finally, and specifically in light of the pandemic and increased discussion of global health inequalities, I'm going to focus on the political economy of global health by examining the role of the World Bank's structural adjustment policies on the healthcare systems of developing countries, and on the impact of the WTO's intellectual property frameworks on access to medicines. Now, I think that this brief examination of global health will provide an opportunity to look through some of the current and controversial issues that have been highlighted by the pandemic, including about diplomacy, about global cooperation, and inequality. But I also recognize that this is a fairly siloed approach to the problem, right? So many of the issues which are arising out of the pandemic, in fact, cut across several topics on bubbling international law. We can't simply say it's one topic of global health. So it's perhaps more fruitful to embed these discussions within international law teaching more generally. So, which brings me to the second possible response that we can have to the pandemic. And that could be about moving beyond the addition of a topic on the regulation of global health onto the syllabus. It would in fact involve teaching the same topics and concepts as in any other international law module, but threading the pandemic throughout the teaching in order to add a flavor of how global crises can help us to think about international law. So, for instance, one of the standard topics in an international law module is sources of international law, in which we usually spend a considerable amount of time talking about the sources set out in Article 38 of the statute of the ICJ. The pandemic, of course, raises a number of interesting issues relating to sources. So, for instance, what is the legal status of the international health regulations of the WHO? Can state actions at this time create instant custom? We can also examine who is left out of international lawmaking processes. There's also a wealth of material when it comes to the pandemic and subjects of international law. Now, the state is one of the primary actors in international law, and we also often focus on the criteria set out in the Montevideo Convention. So permanent population, defined territory, government, and capacity to enter into relations with other states. But there's also a lot of scholarship on the constructed nature of the modern nation state and on how specific entities are included in or excluded from the international order. The pandemic has laid bare the multiple ways in which states exercise control over their territory, including through methods such as border controls, lockdowns, surveillance, and the provision or not of public and health services. So by discussing these activities, we can move beyond the list of formal criteria, which is set out in the Montevideo Convention. We can try and unpack the complicated structure of the state. In addition to the state, we can obviously also discuss individuals and international organizations when teaching about the subjects of international law. The role of the WHO in the pandemic can also provide a lens with which to explore international institutions and their international legal status. I think that highlighting a lot of these issues can be worthwhile, but focusing again on threading the pandemic through specific topics which already exist, it somehow flattens the complex global landscape of actors. It places an overwhelming emphasis on specific incidents and events rather than the broader structures of international law. So adding some critical elements to a fairly traditional syllabus basically retains the basic structure of the module. It may not help us to completely rethink the structures of international law itself, or to examine how international law operates in specific contexts. The contextual approach is important to understand the significance of the multiple roles that international law can play in world affairs, and the many ways in which it can and is shaped by different actors. And this brings me to the third approach to rethink our teaching in light of the pandemic, the old-fashioned Moot, which Udoka had also talked about, right? The Moot has long been considered to be an important means through which to teach law. We can use concrete problems and case studies. We can demonstrate the complexity of the international legal space, the variety of perspectives in relation to international law, and the manner in which different actors interact with and use international law. Now, drafting a Moot problem, of course, is an art. It takes time and effort. For international law, of course, we can try and just use the law problem, which is usually organized by JESSOP, right? JESSOP Moot problems are often deal with very current issues. The Moot problem for the 2021 edition, for instance, revolves around the fallout of the JVID-18 pandemic, which sounds a bit familiar. So focusing on an actual problem can help students to think through connections between various international law concepts that they might find hard to do in a more traditional international law module. And the approach of a Moot also fits with the scholarly emphasis on active learning techniques over traditional transmission-based lectures. Of course, there are concerns around the structure of Moot courts, particularly in relation to gender bias and their excessively adversarial nature. But I think there are ways to address these issues in order for Moots to provide an enriching experience for students. And finally, I just want to briefly address the possibility of using the pandemic as a moment to rethink the organization and structure of the undergraduate law module as a whole, perhaps. The pandemic has reignited a focus on the specific topic of the regulation of global health, but also broader concerns about global inequality and the role of international law in the creation and maintenance of hierarchies. And these concerns have in turn demonstrated the inadequacy of teaching in a manner that focuses on states as the major actors of international law, or as sources being confined to the ones listed in Article 38. So one way to deal with this problem is, as I talked about before, is just add critical elements to expand the existing doctrine. But moving beyond expansion, we can also think about perhaps reorganizing our teaching. And I've given some brief thought to this, right? So how can we reorganize our thinking? And I thought we could try and reorganize it into three main parts. So relationships, players, projects. There's a considerable amount of critical scholarship on how international law is structured by dualities, right? So these include the domestic and the international, autonomy and community, private and public, rule and justice, law and politics. So I think it's possible to teach international law through the lens of these relationships, which are both theoretically rich and historically grounded. So for instance, the doctrine of sovereignty demonstrates states' desire for autonomy, as well as the aim of creating global communities. The public-private relationship can be brought to the fore in the consideration of sources, particularly in relation to the assessment of private law as an analogy for public international law. By focusing on relationships, it's also possible to highlight the tremendous complexity of the landscape of international law players. Though the state is significant, so are international organizations, transnational corporations, private actors such as non-governmental organizations or charitable foundations. And by focusing on this wide variety of actors, we can also define international law to be a series of projects that these actors are and have been engaged in. So this could be these include the management of violence, of world resources, of health, and of imperialism. Now, reorganizing the international law module around these themes can also help us to turn a critical eye towards what international law excludes. So we can examine who are not considered to be important players in international law, or what projects are not considered to be important for international law and why. And this final approach is perhaps the hardest to carry out, since it requires a significant amount of effort and may be challenging to implement at the undergraduate level. I think it's complicated to try and figure out which one of these four approaches that I've talked about today, which one of them should we try and implement, right? I think the choice depends on a number of different factors. There are pressures on the delivery of teaching. There are workload issues in light of the migration to online learning. There's economic and physical insecurity. All this will, of course, have an effect on the amount of effort that we can put into redesigning our teaching. And our choices are also framed by the broader context of higher education that includes the long-term defunding of public education, the focus on so-called high-value STEM degrees over humanities or social science degrees. And I think that this broader environment will influence our ability to rethink our teaching. I also just want to acknowledge that in light of a humanitarian catastrophe, it's perhaps a bit of a privilege to be thinking about how to rethink our teaching of international law. But I think the pandemic demonstrates there's perhaps greater need than ever for critical engagement with law and legal structures. And this critical engagement and contextualization is key to decolonizing our teaching of international law. Thank you very much. I look forward to your questions.
Thank you very much, Priyasa, for an excellent and very, very rich presentation and truly thought-provoking, in many respects, together with the proposals you put on the table. As I said, in all four presentations, I found common threads. The common threads that bridge us together, whether it's contextualization, what Priyasa proposed at the end, excuse me, or whether we are talking about the situated knowledge, or whether we are talking about particular events. They're propositions that define nuances, and that's very, very, very important. Having said that, we have a couple of questions on the Q&A. So the idea is to summarize some questions. I think actually Priyasa's last presentation touched upon one question, but I would like to address these questions, although one of them was addressed only to Udoka, to address to all of you, and to give the floor to all of you. And then I think it would be important if some of you, I know Giovanna already has a question, for Udoka, if you have questions for your co-panelists, to raise these questions, and maybe, definitely Barry, myself, we have some questions we would like to add, but it's very important to give the floor back to you, and to share more of your thoughts and your comments. So there is an initial question of the Q&A, which I thought it was quite interesting, and it's quite provocative question, and it was addressed to you, Doka, initially. To what extent, the language of decolonization, the language of trail, of critical scholarship, reflect a kind of Western academia language, vocabulary, that maybe it's not enough. It's not enough, in order to produce this reform of international law. So one suggestion was, what would happen if states withdrew from all these treaties, instead of just ending? And I think Priyasa's last comment, to some extent respond to this question, is it enough to add some critical elements, some critical components, or a more, I would say, sweeping, a bigger reform, should be the answer. So this is a question that I would like to address to all of you. And then there is a question, Giovanna, for you, especially about Brazil and the curriculum, to what extent, since you have 5 years, 6 years, but then there is this competition between legal elements, subfields. What would be the proper way, for international law to be given more attention? So let's start with that. I would like to give the floor to all of you, and then we can continue. So maybe, sorry, Udoka, would you like to respond first, and then the others? All of you,
Okay, thank you very much, Morris, for the question. It's it actually requires a bit of unpacking of the question, because it contains quite a bit. But I agree with you that TWIL has been, initially TWIL was mostly exogenous, so taking place in elite Western universities. But again, by third world scholars who were in elite Western universities. But increasing TWIL scholarship, there is increasing TWIL scholarship, not just on the continent, but as well as in Asia. So for example, if you look at the Teaching and Research of International Law in Asia project, which is a big project, and you will see that is why we're advocating for introduction of critical theories in Nigeria. I also agree with you about the problematic nature, of international law in the very design of the international law as a system, including its lawmaking processes, in which there is entrenched, hegemony, great power privileges, and inequality and exclusion, political exclusion, which makes it difficult, to change state practice or to reform international law. However, I don't agree with disengagement with international law, which is by mass withdrawal of states from these from international law, from these treaties. I don't agree with the disengagement with international law. And indeed, that's not what TWIL is all about. What TWIL does is to offer an optic of viewing international law, an optic which sees and resists inequality and dominance. And hopefully by seeing and resisting it is going to, inform and create agents of change from within the system. So resisting this, and I also see the point that you make about the resistance in the 60s and 70s to reform by these great power privileges. And that's precisely, what TWIL is all about, that it shows it, and also resist it. You resist it, it shows it and resist it. And but the idea of a mass withdrawal, I think it's not politically tenable. I don't think it is a practical one or a tenable one. But again, these are things that inform our understanding of international law and agitate, the minds of international law and everyone walks towards reform of international law and, not being excluded from the reform of international law, bearing in mind, the interests everyone brings and, situationality of everyone. So sort of an international in international law, to reflect that. So those are, I hope that answers the question for you.
Thank you very much, Udoka. I would like to give the floor to the other panelists as well, if they would like to share their thoughts regarding this question. Who would like to take the floor? Giovanna?
I'm just trying to mute myself here, manage. So I think maybe again a little bit different from Udoka. I would love it to have like a fresh start, for us to think about international law. If we could have all treaties gone and start thinking and approaching it. I'm not sure, Maurice, if we would end up with something extremely different, to tell you the truth. But so these are the risks now whenever we're talking about renegotiating a treaty, is like moving backwards instead of forward. So yeah, I couldn't really be 100% sure on that. But I think like the point that I wanted to make, or maybe to raise to attention is like things is, I think my talk was like basically like, oh, don't ask us lectures of international law to be a hero and change the world with like our approach to decolonization. We also like involved in having to put ourselves within this context of the structural change, the institutional needs, the needs of our students and so on and so forth. But to a certain extent, we rely on our students being a little bit of a hero, no? So I think, and I think maybe that's where I get maybe the, how can I say, potential of using these approaches and trying to bring a little bit more of the critical aspect into it. And then I might be moving, maybe like following a little bit from the international public law as the topics that I said discussing, but maybe moving a little bit to the field of human rights or international environmental law, where we can actually see maybe even international criminal law, but they're a little bit like, I think it's a little bit trickier. But I think maybe when we open up a little bit more this space for the individual to participate and to engage with the instruments on international law, be it as a lawyer petitioning before a specific, how can I say, institution for us, would be the Inter-American System of Human Rights, or bringing, like, for instance, as the indigenous communities in Brazil did recently, bringing to attention of the ICC the crimes that are being committed against them. So I think, like, when you kind of open up these possibilities, when you're dealing with the topics and bring to the attention of the students, you know, these instruments are there. We need to learn how to use them and how to make sense of them for us from an individual perspective, not only from the state perspective, no, like, because Brazil also has lawyers defending them on the Inter-American Court of Human Rights. And we open up like this discussion and bring, for instance, in terms of international environmental law, we've seen the development, not only on the international level, but domestic level, of recognizing rights of natures and putting forward, how can I say, this type of reasoning. I think there is a potential over there. Maybe not, how can I say, as strong. I don't think we would manage to change like all the time. And it's a petition that, for instance, my PhD was on the participation of victims on the International Criminal Court. And when I started, I was like, brilliant, we're gonna change the world, you know, the victim that actually suffered the crime gonna now be having the opportunity to talk and put forward their views and so on. But we see structurally how the participation has been cutted and limited again and again and again, you know, so it is a challenge. And I think it's really, how can I say, it won't happen like as clear cut and the potential, but I think there is the potential there, and might be like, how can I say, just maybe trying to believe that we might be able to do something on those lines. And that those terminologies and those critical perspectives brings us not only like, how can I say, and this is a common criticism, not for all the critical perspectives, just like, oh, we're destroying them, don't build anything. But maybe by destructing a little bit, we kind of open up, like with the strategic litigation, and some opens up the space for something different a little bit. So I think maybe that was my view on the overall potential of using the terminologies and these perspectives.
Thank you, Giovanna. I know that both Carolina and Priyasa would like to add their thoughts. So Carolina, first you have the floor, and then we go to Priyasa immediately.
Okay, thank you. Yes, I definitely agree that we should probably be careful with using this terminology, like decolonizing everything, and you know, using these words on and on over and over again, but mainly by the elite institutions in the West, because that, I don't think that adds too much to the discussion. But I am definitely opposed to withdrawing from all of the treaties, as already Giovanna mentioned about the ICC Rome Statute. This is something of a trend in the last couple of years when the states started withdrawing, but I also, in my PhD, I am actually writing about the domestic prosecutions of war crimes, using the very much domesticated criminal law statutes that are implementing international criminal law in the domestic legislation. And I think that is really the future. So instead of withdrawing from the international treaties, rather justice ownership as a phenomenon. So instead of you know, always using the international sphere, rather taking the ownership of this international law and transferring it into something that fits the domestic criminal law procedure, and then using that to, for example, prosecute war criminals domestically. I think that is really the future. Whether we should be using this terminology that we are currently using, I'm not sure. But I think there is definitely a lot of potential with the existing international treaties, just on a different scale.
Thank you very much, Carolina, for this component as well. Priyasa.
Yeah, thank you. I'll be quite brief. I think our role as educators is probably quite limited. In the sense, obviously, I would like to. I think of teaching critically largely to provide context to law to my students, to say that there might be an alternative. But I think the university is a very limited space for us to actually provide that alternative. That alternative has to come outside. We need to build political solidarity and political and social movements outside. So teaching, I think, is one element, whether it is decolonizing or critical teaching or whatever we want to call it. But for us to actually make a difference, we need to step outside the university.
Thank you very much, Priyasa, for this very brief comment. Udoka would like to add something, and then I will proceed with 2 more questions.
Okay, thank you. Thank you very much. I actually wanted to thank Sean Morris for that question, because what he did was to, you know, problematize a big thing in international law, and obviously by bringing out the fact that a lot of these treaties, you know, were concluded. A lot of these treaties were concluded. Look at the power dynamics and the inequality in the conclusion of these treaties. A lot of the treaties were made, and when African states or states in the third world weren't sovereign states. And so it's problematic, and therefore many of them, upon gaining statehood, acceded to these laws that, or acceded to these treaties that were already in existence, that didn't take into consideration their interests. And so that's very important that he draws out. Again, that's what, you know, scholarship like TWIL wants to show, and therefore would inform things like renegotiation of treaties, or even going for the negotiation of treaties by agency, you know, representation and ownership of, you know, of the third world in international law and international law legal processes. And so that's something, and I wanted to thank him for that, because that's something that agitates our minds and agitates the minds of international.
Thank you very much, Udoka. I think we have a couple of minutes. So I would like to use this remaining time. We have Barry has a question. It's about history. It's about histories, to what extent it is addressed to all of you. You know, how do you define, how do you understand the role of history while you're teaching international law? What kind of histories do you use? What kind of narratives? For which purpose? You know, as he asked, is it for persuasion? Is it for understanding? So I would like to, we would like to know your thoughts on that. I have a question myself. I'm very intrigued. I have to say that I struggle myself many years with what kind of teachers, what is our role? Anyway, I'm not going to take the floor here. You know, how can we deal? How can we balance, as I keep saying in my work, between critique and faith to some extent? You know, when we deal with whether it's massive phenomena or with the inequalities, with the prejudice of the system. So my question to you is, how do you understand the role of universality within the decolonization? Is there a space for universality? And I think that goes back, you know, to what Udoka at the beginning, you know, when you were talking about the disengagement, you know, how can we find this balance? Is there any role for balance? Or again, maybe it's the same question, you know, should we go for a more extreme, I don't speak on behalf of anyone, you know, for extreme solutions? And I think, Giovanna, you had a question for Udoka, you know, about, would you like to address that to her? And then maybe with these questions, we can wrap up, you know. Thank you.
So my question was basically, Doc, and it's a reflection a little bit of my experience teaching at the postgraduate module in Brazil. So I had a module that was titled like Critical Theories of International Law, where we addressed TWIL and feminism. And I have quite a bit of a resistance from my own students on why are we doing that? Why are we looking at these issues? No, this is the word as it is out there, and we have to, how can I say, learn how to play with the rules. And it's unfair, but that's life, you know? So I was just wondering whether you actually have faced something on those lines, and whether you could share your experience and how you addressed it. That was like my question.
Excellent, thank you. So the question is to you. Who would like to take first the floor, ladies? Whoever wants to take the floor. Udoka, would you like to start, or?
Okay, in answering Giovanna's question, that's what I talked about, the apathy to international law, you know, that students, which you are also facing, you know, why bother? You know, what's what's there for us to do. That's the way it is. And pretty much, again, like I pointed out, the NUC, the BMAS, the benchmark minimum academic standards is saying, the law as it is, and so sort of saying, what can you do? You conform, and so it becomes difficult. It becomes difficult for you as an international law teacher, and that for me is why I think that the introduction of critical thinking is important. It's important because then you expose the students to you expose the students to even expose yourself about what your own, because you the teacher might, what your own biases are, how you view international law, because in your mind might be, okay, it is what it is, and most of us just, you teach, you don't engage the material, and then you have these questions but sort of think that there's nothing that can be done, and therefore you go about, you teach students the same, and so you find a replication of the system. And so that I think that introduction of a critical scholarship is an imperative, not just for the students, but also for teachers as well, because then as teachers, we relearn, we put ourselves in the position of the students. And again, mind you that the international law has different effects on the differently situated. And so you're conscious of where your students might be coming from, what their experiences are, how they see international law, how they see the world, and it helps you to, change the teaching. So pretty much I still experience and see that apathy, but I try to deal with it. Again, I also have to say that dealing with it in the 5th year of law studies, I think is somewhat late. I think it's somewhat late when the students have been exposed to uncritical thinking from much earlier, and the same time, the first 4 years of, and you might actually be the only one who's doing that of all the courses that they're doing. And so it seems as though you're swimming against the tide. So it's, I think that's the task for us as international law teachers, to keep engaging in these discourses and to keep challenging ourselves and thinking of how to, make it better.
Thank you. Thank you very much. I think this self-reflection, the acknowledgement of our prejudice, of our biases is very, very important. And it shows exactly that the picture is way more nuanced than black and white. The rest of the ladies who would like to take the floor on to share.
I think I can try, like maybe from my own experience, to address a little bit, how can I say, Barry's question. And I think it's kind of interesting. And how can I say, on my own perspective, Barry, and here I have actually to assume my training and so on. So I did study international law in Brazil, and I studied with Cansado Trindade. So over there, how can I say, we kind of have a reference and how can I say, a clear point on where to kind of draw some of the lineage and some of the debates that would look at a different way of looking at human rights, even though he himself is, how can I say, has been trained, has the PhD from Europe, I myself, actually, most of the training that I have was like at Stockholm and Uppsala University, and again here at Nottingham. So again, we see that maybe the concept or the point that Maurice made is like it's a Western concept, might not be too far away, So we moved here to actually get to talk about Twail and so on. So I think, like, for instance, in my modules, I will assume here, like, I didn't really, how can I say, look much or address history from too much of a different perspective than what we would have. But I remember, for instance, but I think, like, the point that I want to make is, like, I think when we do it, we have to let our students know what we are doing and for what purpose. Because reflecting again on my experience, I did have a lecture that actually has a project where we needed to identify within legal scholars in Brazil what they were producing. And we look at it, it's just like, why? Why are we looking at the past? Why are we trying to look at what these individuals are doing? What is the meaning of that for us? And that wasn't clear. So I think this is kind of an important element. We need to understand and make it clear why we are going on those routes and trying to identify those lines. I did my project, like my dissertation in Brazil, looking at some of the history. So this is kind of research-wise, not dealing with the students. And what I found is just like for us, I think in terms of international law, we did have, thinking of law in general in Brazil, we had a really significant impact of, how can I say, positivism on the way we think about international law. And this has to a great extent framed the way we position the relationship, or how we think about international law in Brazil. Like what, how can I say, the concepts, the objects, and how we share and relate them, like, or even the debate about is international law. Most of, like, how can I say, significant amount of the courses are going to still have the space on that. And that debate is framed within the perspective, like, well, we follow a positivist perspective or understanding of international law. So these, I think, how can I say, it's some of the challenges when we're dealing with building, for instance, or identifying our own history. You know? So what are our own contributions? We did have like important names like within international law too, but I don't think we have like how can I say, completely explored this history. So I think there is a space over there for us to do research. But the contributions sometimes are limited by this positivist perspective that has framed the way we understand law in general in Brazil.
Thank you. Anyone else? Would Carolina or Priyasa? Priyasa, I see it. Yes.
Sure. Thanks for the question, Barry. I would like to do more history of international law in my modules. There is unfortunately not that much space or time for me to do all the history that I want to. I think of the reason I think history is important is because I think it tells us why we are where we are and how we got here. So most of my use of history, or the reason I tell my students why history I think is important, or why I tell them to try and understand this history or pass through that history, is to try and understand the law today and why it is the way it is. And perhaps that might help to think of alternative ways in which we can think about our legal structures today. So that's the primary reason why I rely on history to the limited extent that I do. And that's how I use it as well. Kinds of narratives. I know there's a tremendous debate on appropriate methodologies of writing the history of international law. Obviously, an undergraduate module is not a space where I can discuss any of those scholarly debates, so I usually try and lay off them. But the kind of narratives I use are usually to just try and bring in the perspectives of the peripheries, for the lack of a better word, into our understanding of international law. So that's about the histories. Maria, on your question about universality, I think that's really interesting because I think that's a struggle to try and balance the particular and the universal. And most of what we have done, if we teach or think about anything from a post-colonial perspective, is that everything is a particular. But I think it's also important to realize, or perhaps to teach, that all these perspectives might be particular, but they aspire towards universalism. The question is just which one wins out and becomes the universal one. So I think I know that's not an answer, but that's the only thing which comes to my mind right now. Thank you.
Thank you very much for that. I think Carolina would like to add a final word on this. Thank you.
Yeah, maybe just briefly, because I realize we don't have too much time. So maybe in relation to, again, going back to international criminal law, because this is my area and this is what I can think of. With regards to studying the trials, for example, I think it's extremely important to think about the history, to study the history in relation to trials, for example, in Cambodia, the Icrc, or the ICTY, or even, I think, yeah, all the other tribunals. It's something that should not be sidelined, and something that I think should be in the back of the heads of the trial lawyers. Not only the victims' rights, not only the impact of the trial at home, but also the wider context. But when I think about the region where I come from, and if we are going to study the history of international criminal law, for example, in Poland, I think it actually has more potential to limit the perspective than to broaden it, because I think at least the scholarship that I am familiar with it's mostly, for example, the Soviet trials, after the Second World War, that ended up with death penalty, or other kinds of, for example, in relation to transitional justice, and it mainly focuses on, for example, lustration. So it is very limiting to, for example, something that I am trying to argue in my research. It's completely not applicable, because I'm trying to argue that Poland should open a war crimes unit, the same as there are war crimes units in so many different Western countries. They're trying, war criminals from Syria, they're trying war criminals from other places. And it's really hard to advocate for something like this when the discussions about the history of international criminal law are that limited to these kinds of very narrow historical perspectives. So I think it's a bit dangerous, and this is also the danger of, I think, universality. That's what also I briefly mentioned in my presentation, that these kinds of case studies, they cannot aim to be universal. They should always highlight that they are very limited and very region specific, and they should not try to universalize any of these ancient rules of warfare and trying to, again, promote IHL in different regions by saying that, but wait a minute, in this region that is, for example, 1,000 kilometers away, there was this rule, that's why you have to accept it. No, it should, I think we should be really careful with that. So yeah, that's what I wanted to add.
Thank you. Thank you all very much. We cannot do justice to the topic and the questions that are triggered by this topic. And all of you, you have raised so many salient and important topics. I wish we had time, to discuss more and more and essays. We cannot do justice, like this last question, about universality or the concept of decolonization and the various nuances. Having said that, I learned so much from you. I'm extremely grateful. I want to thank all of you. And I want to thank you because I thought that it was extremely self-reflective session, and it's very important to have speakers who speak, knowing what they are talking about, not on an abstract level. And this is the added value for me. So having said that, I would like to give the floor now. I want to thank you once more, for joining me in this discussion and this interactive, actually, discussion. And I would like, excuse me, to give the floor to Jean-Pierre and to Barry for the final comment. So on my behalf, thank you very much for this discussion. I learned so much. Thank you.
Thank you very much, Maria, and thank you very much to all the speakers. This has been absolutely fascinating. I appreciate that we're already over time, so I will make this very brief. As we come to the end of a series, it's a series that Barry and I have been talking about now for, I think, about a year and a half. It's been in the making for a long time, and it's been running for the last 3.5 months or so. And it's been an absolutely fascinating experience talking to people teaching international law in all sorts of contexts and raising all sorts of different questions and issues that they face, and being, as Maria just said, self-reflective about what we're doing, why are we doing it, how are we doing it, and are we doing it well, and how can we do it better. And I think that was very much what we hoped to achieve out of the webinar series. When this was originally planned as a 2-day conference before COVID was a thing. So that's how long it's been. But with all that being said, I think that key goal that we set out to achieve through the conference and through the webinar series has been achieved. And I think today's webinars were kind of a pinnacle of that in really bringing that conversation forward. So with that said, I just have a few words of thanks before we close off. First of all, to our speakers today, but also our speakers throughout the last 10 webinars, to our chairs, Maria, as well as all the other chairs that have chaired the other 9 webinars in the past weeks, to our attendees for your participation, your questions, your engagement, both during the webinars, but also via social media, etc. The organizing committee that was critical in helping us pull this event together, pull the webinar series together, help select the papers that were going to be presented, but also kind of frame the narrative that would come through the webinar series. The BICL events team, Liam, who is the events manager at BICL, behind the BICL logo, as well as Bradley and Carmel from our marketing team, who are responsible for making sure that the event runs on time, that the technology works and that people are registered and that the people receive the reminders for all the events, making sure that the recordings go up on the website, etc., etc. Thank you so much to all of you. We would not have been able to do this without you. And finally, my thanks to Barry, who is the co-convener of the series. Again, it was a fantastic experience working with Barry on organizing this, and I look forward to working further with all of you in the future. With that said, Barry, I don't know whether you wanted to say anything.
Yeah, I mean, just to reiterate all of the thanks that you've given there, Jean-Pierre, and to say, you know, that this is just, you know, the continuation of an ongoing conversation about teaching international law. You know, it wasn't the first thing that's said on teaching international law, and very much hope it won't be the last. I think there's so much more to be said in this space. It remains an underexplored, under-researched area. And so, you know, one of the things we were hoping was that, you know, while we're building on what's come before, we hope it will also kickstart more conversations in the future. And that said, thank you to everyone today. Thank you to all the panelists. Thank you to all the attendees, and wish you all a very good weekend.
Thank you all very much. Thank you.
Thank you, everyone.
Thanks.
Bye-bye.
Bye, thank you.